Okay, good morning everyone. My name's Emerald Priscott and I'm a family law solicitor. So I have two hats in my role. I deal with kind of divorce, separation, unmarried couples, and then I also deal with the cheery topic of contested probate, so when somebody's passed away. So that's what I'm going to talk to you about today. We're going to kind of do a whistle-stop tour of it because I could stand up here for half a day and probably bore you all with it. But if you do have any questions at the end, then please fire away. So the first thing, well, we banned this term around. What does contested probate actually mean? Well, it covers a wide variety of things and essentially is any dispute about a deceased person's estate. So it might be disputes about a will, it might be disputes about assets in the estate, disputes between executors, which is the case that Neale alluded to, I've got going on in London at the moment, feuding beneficiaries. And there's also this other branch where there may be financial abuse. So while somebody's living, there may be LPAs in place and people use their role as potentially as an attorney and they abuse it. And then that's only found out after the deceased person has died. So the next question is, well, how common is it? We have seen in the headlines these things of, I've been left out of such and such's will, I want to contest a will. But actually, it's relatively rare. So I just want to put it into perspective for you guys. In 2017, these are kind of the most recent statistics I could get, there was just over 533,000 deaths in England and Wales. Now, in relation to that, there were 80 contested probate cases which reached the High Court. So that just shows, actually, it is quite rare. But of course, that doesn't take account of the cases that didn't get to court, the people who made kind of initial inquiries, took some advice, but then didn't, take it any further. All those cases that actually settles outside of court. So it's difficult to kind of put statistics on it, but that gives you an idea. Now, has there been any increase in recent years? Well, lawyers report that there actually has been. But why do we think that is? Why do you guys think there's been an increase in people challenging wills? Anybody got any ideas? I've got my thoughts, which I'll go through. But has anybody got any ideas?
Possibly because of these will makers.
Yeah. Homemade wills. Yeah. Will writers. Yeah. Yeah, exactly. That's touched on some of the things that I've come up with. I mean, I think that there are a number of reasons. One of the reasons is that we are now living our lives in very different ways. We are living within blended families, which have complex family structures. It's quite normal now for one person to have 1, 2, 3, 4, 5 families throughout their life. And they may have cohabited with somebody, they may have married someone, they may have then divorced them and then remarried. And all of that actually brings further scope for argument. I don't think we're quite at the US stage of kind of ambulance chasing within this industry, but I do think that there is a growing compensation culture in this country, and people are definitely more aware of their legal rights and the ability to bring claims, and there does seem to be this kind of more of an appetite for litigation, or at least that initial kind of I'm going to take a punt, which is absolutely great for the lawyers, but may not be for other members of the family or the deceased person. Also, society is becoming wealthier. So house prices, land prices are going up, so estates are becoming larger, and so there's more to argue about. And if there's more assets, then again, people are more likely to see if they can take a punt on it. We're also living in a difficult financial climate. I don't think that we can't beat around the bush, about that. And there is this expectation, which may not have been there a couple of decades ago, that people will inherit from older generations. It's increasingly difficult to get on the housing ladder for young people, as I know. And, you know, older generations, they may not have made pension provisions, things like that, but they're thinking, oh, it doesn't matter because I might inherit from mum, dad, granddad, auntie, whoever it is, you know, and then I can invest that and that will provide me with a pension. It's also a hot topic in the media, and Neale touched on the case of Islet and Mitson, which I will go into in more detail, but the red top papers absolutely love to report on this kind of thing because it's a juicy scoop for them. So I think those are some of the reasons, and there's definitely a growth in DIY wills, will writers, that kind of thing, which I'll also go on to, and that may be why there has been a rise in recent years. So in 2018, Direct Line did some research, and they surveyed 2,000 adults on their attitudes towards challenging a will. Now I've got another question for you, because I appreciate you've sat through a lot of things, so we've got to keep you active, got to keep you awake. What percentage of people do you think said that they would mount a challenge to a will if they were unhappy with it? So somebody throw a percentage at me. 70%. Okay. It was slightly less than that, but that would keep me in business for a long, long time if it was 70%. They had the survey, the people surveyed, it was actually 24% of people said that they would challenge a will, okay? And they also looked at different areas around the country, and they looked at Norwich, so I'll just touch on that because we're not far away. And in Norwich, 19% of people said that they would contest a parent's will if they were unhappy with it. 18% would contest a partner's will, and 29% would contest a loved one's will generally. So they sit kind of, you know, in the average in terms of the research that was done.
Because it comes back to legal expenses, doesn't it? I can't afford to contest it. Or
Exactly. It is expensive if you instruct a solicitor to do it. Obviously, there is the possibility of acting in person, but you know, the vast majority of people want to get that legal advice because it's a comfort blanket for them, because it is very complicated and the rules and the procedure is complicated. So yeah, I agree that it's the expense of actually taking that step. Interestingly, the place where the people are less likely to contest a will is in Sheffield. And I don't know why that is, but it'd be interesting to know why people in Sheffield are less likely to contest somebody's will. But maybe they'll do another study on that, who knows. So, how can a will be challenged? Well, there's two main possible bases. And the first one is validity, and then the second one is under the Inheritance Act, which Neale has touched on. And that's basically the idea that somebody is unhappy because reasonable financial provision hasn't been provided for them. So let's look at challenges to validity. So I've just picked out a couple of the most common ones, but there are others. So the first one is the lack of capacity. So this is the idea that the person, when making the will, didn't have the requisite capacity to enter into it. Now, when looking at capacity, the test is set out in case law, and it's also set out in the Mental Capacity Act, which is looked at in conjunction with it. This test is well understood by both medical and legal professionals. It can be difficult to prove that somebody doesn't have the requisite mental capacity, and essentially it would involve looking at the medical evidence at the time and looking at witness evidence. The second one I've got listed there is undue influence. So this is where the person making the will is coerced into making it. Now, I use a quite facetious example, essentially where you get Granny and you say, Granny, you're going to leave your whole estate to me, and you march her off to get the pen and get the bit of paper, and then you forcibly get her arm to sign it. Often it's a little bit more subtle than that. I haven't had any cases where that actually has happened at the moment. Because it is more subtle, it can be, again, difficult to prove, because you've got to show that the testator's judgment was completely overborne. The third one is the lack of knowledge and or approval of the terms of the will. So this is the idea that the person making the will didn't really actually understand what they were signing, didn't really understand the effect of the terms, so there may have been complex trusts in there, and if a will writer or a solicitor was involved in that, then there may be questions about whether they adequately advised them on those terms as well. Another one, non-compliance with formalities, which links back in with the growth in kind of DIY wills. There are a number of formalities that are set out in law in relation to making a will, and you need to comply with those. And people are not necessarily aware. It gives me the absolute heebie-jeebies when I see a advert on the television advertising whatever service it is, and then they say, and get your free will pack. I just think, oh no, because people will enter into something like that and they may not have regard to all of the formalities in the Act, and that can cause huge problems later on for their families, for their loved ones, which they may just not have envisaged. So what happens if we succeed on those challenges? Well, challenges 1 to 3, the will is deemed as being invalid. But what does that actually mean in practice? Well, if there is a previous will, then we'll revert back to that. But if there's no previous will, then the person will be deemed to have died intestate, and their estate will be distributed under what's called the Intestacy Rules. Now, the Intestacy Rules are a set of arbitrary rules which essentially set out the people that should inherit in a list. And if you die without any living relatives, then your estate will go to the Crown, which I'm sure nobody necessarily wants. And the Intestacy Rules, there are a number of issues with them that we will touch on as we go through the slides. And then on challenge 4, so the idea that it doesn't comply with formalities, the will may be invalid, but it also may be able to be rectified, which would involve a court application. And alongside all of this, you know, people have to have in their mind the potential issue of professional negligence. You know, did the will writer, did the solicitor do all that they should have done in advising them? So that might be something that they also need to consider. So then we come on to the second main challenge to it, and that's challenges under the Inheritance Act. So if the will is valid, then certain family members or dependents can make a claim if reasonable financial provision hasn't been made for them in the will. So the next question is, well, what's reasonable financial provision? And it's case specific. There is a number of factors that the court will take into account, and it will depend on the nature of the relationship between the will maker and then the person potentially making the claim. Now, these type of claims are time limited, so they should be made within 6 months of the grant of probate. Otherwise, you've got to make a separate application for permission to apply out of time. So, Eilert and Mitson, this was a case that looked at the Inheritance Act. Just a quick show of hands, how many people have heard about Eilert and Mitson? I'm so pleased when the lawyers put their hands up. So we'll just quickly recap the facts for those who don't know about the case. So Mrs. Jackson died in 2004. She had a modest estate of £486,000. She had one daughter, Mrs. Eilert, who she was estranged from. Now, there had been some problems in their relationship, and essentially Mrs. Eilert went off when she was 17 with a partner who Mrs. Jackson didn't approve of, which I think is quite funny actually, because she then went off, Mrs. Eilert went off with this new partner, and she went on to have 5 children with him, and as far as I'm aware they're still together, so she didn't approve of him, but it was actually quite a stable relationship. So Mrs. Jackson in her will left her estate to 3 animal charities, which were the Blue Cross, RSPB and the RSPCA. Now, she didn't have any particular connection with these charities, but with her will there was a side letter essentially saying why she had left Mrs. Eilert out of her will, and she instructed her executors to contest any claim that was made by Mrs. Eilert. So Mrs. Eilert went on to make a claim, and it went to the county court at the first instance in 2007. Now, the court concluded that actually Mrs. Jackson had failed to make reasonable financial provision for Mrs. Eilert, and said that she should be awarded £50,000. And they limited it to this amount because of the nature of the relationship due to the estrangement. It was then challenged again, and in 2014 it went to the Court of Appeal, and the court said no, it should be a little bit more than that actually. and they awarded her £143,000, which would have enabled her to buy her housing association house. Now, Mrs. Eilert was she was receiving financial help and benefits, so that's something that the court took into consideration. She's largely reliant on state benefits. Now, it was appealed again in 2017 because the charities were worried, actually, is this setting a precedent? Because a large portion of their potential legacy could have been impacted by these decisions. And it went on to the Supreme Court in 2017. So we're 10 years on in the litigation. So these things take time. And so they actually reinstated the county court decision and said, actually, no, the right award should have been £50,000. They said that the test for reasonable financial provision is objective and what is reasonable in all of the circumstances, and it's fact dependent. And it's quite interesting that the Supreme Court actually said that it would have been legitimate for the first instance judge, so all the way back in 2007, to make no award at all. So you can see that there's this quite a large amount of discretion. So what do you think about the decision? Do you think it's a victory for testamentary freedom or not? Has anyone got any immediate thoughts on that decision? All stunned into silence. I think the thing is we're supposed to have testamentary freedom in this country. We are, in theory, allowed to leave our estate to whoever we want, but we've got the Inheritance Act that's kind of going into that a bit and touching upon that. So it's very interesting. It'll be interesting to see how it develops. Okay, so now we've done a bit of the theory, let's put this into practice. So here we've got Rod Stewart and his family, and he's a perfect case study for this because he has been married, he's been divorced, he's lived with people, so he's got a truly blended family. Now, I have to apologise in advance if anybody is an avid Rod Stewart fan, because we are going to go on and unfortunately kill him. And I said this at the last presentation, and then I was thinking, oh goodness, if I come back to my iPhone and there's a notification saying Rod Stewart's died, I'm going to feel awful. Okay, so this is Rod Stewart's family tree. Apologies if you can't see it, it is in your packs. But basically, it's got Rod Stewart here, and then his wives and partners at the top, and then his children down here, essentially, okay? So let's rewind back to 1983. So that would have been 3 years before Neale qualified. And just to clarify, I was not born then either. So Rod and Alana are in the process. So Rod is married to first wife. They're in the process of separating, but they haven't yet divorced. He's got 2 children down here, Kimberly and Sean. He started living with Kelly, his new partner, and he thinks he's found the one. He's been a bit lazy and he hasn't got around to writing his will. He says, "I'm young, nothing will happen to me." So, unfortunately, and here it comes, there's a tragic accident, and the next day Rod dies. Well, what happens? He's still technically married to his first wife, but he's living with his new partner. Well, because he hasn't made a will, he'll die intestate. And that means that his estate will be distributed according to the Intestacy Rules, which I touched on earlier. So what does this actually mean? Well, his personal possessions would go to Alana, and the first 250,000, and half of the rest of the estate. Remember, they've separated, albeit they haven't yet divorced at the moment. And his children, Kimberly and Sean, would get the remaining half equally between them. Now, Kelly would get absolutely nothing, whereas the wife that he's separating from gets a large proportion of his estate. Is that fair? Kelly potentially could make a claim under the Inheritance Act, which we've talked about, but she'd have to show that she'd been living with him for 2 years or that she was maintained by him. And actually, let's think about that. She'd have to make a claim to the court, which is risky, expensive, time-consuming. Does she actually want to do that? So let's fast forward. Let's go to the 2000s. So we're looking at here on the timeline. Rod is married to Rachel, his second wife. It turns out Kelly obviously wasn't the one, so he's got married again. And this time, he has got round to making his will, so thumbs up for Rod. He's been with Rachel for some time. I think it would have been, 10 years by that point. And so he decides to leave her everything in his will. He knows that she will do the right thing. She's got a good relationship with all of the children. Again, unfortunately, tragic accident and Rod dies. Well, Rachel inherits everything under the terms of the will. No specific provision has actually been made for his 5 children at the time, because she gets everything. Well, Rachel decides, well, actually, there would have been a pretty hefty divorce settlement for Alana. Might have been given Kelly some money during his lifetime. I'm going to keep all the money for myself. They've had enough. And that's what the will says, that she's to inherit everything. Let's say she inherits the whole 180 million. I think that's what he's worth at the moment, so he may not have been worth that much in 2000. But she then moves on with her life and she remarries. She puts a will in place with her new husband being the sole beneficiary. She then tragically dies. The whole 180 million, or whatever's left that she hasn't, spent in Vegas, goes to the new husband. So you can see how the money has quickly made its way to a completely new family, which Rod may never have intended. And so that's why it's really important. I'm not doing this necessarily to scare you. Well, I am a bit. But, you can see how you can quickly fall into potentially a contested probate situation. And actually it shows how prevention is better than cure, and making sure you've got all your legal documents in place and so that they do what you want, essentially. So let's have a look at contested probate in the news. Now, this is a Scottish case, but I just couldn't leave it out. So Ross Taggart brutally murdered his mum and then proceeded to bury her under a caravan. And then within hours of doing that, he decided that he was going to go on a night out, as you do. And he actually, and the worst part about going on the night out, he took his mum's credit card, who he just killed, and then spent all of her money on the night out. Now, unfortunately, the mum had left the bulk of her £500,000 estate to Ross, the son who had murdered her. And tragically, she'd actually included a side letter saying how grateful she was to the son for looking after her in her last years. I mean, presumably at that point, she didn't realise he was going to then brutally murder her and then bury her under the caravan. The only good news out of this case is that he cannot benefit under the terms of the will and under the estate. Because of a rule called, in England and Wales, we have a rule called forfeiture, and they have a similar provision in Scotland, which essentially means you can't financially benefit from your crimes. The US tend to do things better than us, and I thought about putting in a joke about Donald Trump, but then I thought, no, best not. So they tend to do things better than us, and their rule, the equivalent of forfeiture, so this idea you can't benefit financially from your crimes, is called the Slayer rule, which I just think is great. And I don't know why in this country we don't have things like that. But the problem in this case, other than the fact that the mum was murdered, was that the son was appointed as an executor. So he was responsible for collecting all of the assets and distributing the estate. And there was nothing in the law preventing him from doing that, even though he had murdered his mum. Now, unfortunately, the family couldn't challenge this because they simply didn't have enough money, going back to your point, to challenge it through the court system. And so they're calling for a change in the law. So we'll see how that progresses, but it's just absolutely astounding. So we come on to 2019. Now, when I was doing my research for this seminar, I was back in kind of late March, early April. And actually, these were just a fraction of the cases that were coming up. And I think that just demonstrates the point that I was making earlier, is that it is on the increase, and the papers are picking it up. So we'll just touch on a couple of these headlines. I won't go through all of the cases, but one of the headlines is Sisters fight millionaire brother after being cut out of £3 million fortune. Here's another one, which is just absolutely awful. Will writer conned 94-year-old out of fortune and then ordered £45,000 Audi and £39,000 diamond necklace for wife. So he was appointed as the person's power of attorney, and he helped him to go into a care home, and then proceeded to spend his money on the Aldi and the diamond necklace, which is just beyond belief. And that's a will writer. That's supposed to be somebody you're supposed to go to trust to manage your finance if you appoint them as an attorney under an LPA, or to write your will. So what is the future? What's proposed reform? Well, we looked at the Intestacy Rules. Now, the Intestacy Rules are from 1925, and so without a will, if you die without a will, then your estate will be distributed in accordance with these. Now, it's reported that 60% of people actually die without a will. Some people find that reassuring because they're in the larger category. Not sure how that fits with my ideas of things, but so the application of the Intestacy Rules is going to become more and more common. Cohabitees, as we demonstrated earlier, don't inherit under the Intestacy Rules. And should they? What should that be based on? So back to the question of, well, should cohabitees get rights? Should the length of the relationship be a factor? Should children be a factor? They're the fastest growing group of families. So actually, there's an argument to say the Intestacy Rules need to change. They need to provide for cohabitees to inherit if their partner was to die. There has been proposed criteria to say that actually, if they've been living together for 5 years, got children, then they should inherit under the Intestacy Rules. Now, under the Inheritance Act, you can only bring a claim if the deceased person died in England and Wales. Well, what about if they die elsewhere? Again, that might be something that needs to be looked at. Now, in 2017, the Law Commission launched a consultation called Making a Will 2017, and that had 3 objectives. The first was supporting testamentary freedom, which is a big question mark, protecting those making wills, and increasing clarity and certainty of the law. So what came out of that? What were the proposals? One of the proposals was wider powers for the courts when it comes to formalities. So if there is an issue with formalities, for example, you have to get 2 witnesses to sign a will. Maybe somebody made their own will and they didn't get 2 witnesses, or a witness was a beneficiary in the will, which you can't do either. So what they're saying is the court to have more powers to essentially rectify that, where not to do so, to make the will invalid, essentially, would frustrate the intention of the will maker. So other than that, their intentions were clear. The second one, which I have a little bit of an issue with, is the idea of supported wills made with assistance. So this is the idea of when someone has borderline capacity, then somebody potentially could come in and help them with making a will, but that just screams abuse to me and more litigation. So not sure how I feel about that. The idea of electronic wills, so we're doing more and more stuff online. The idea that you could sign and execute a will online and then it's stored online. But again, that raises questions about security, cost, accessibility. And then another proposal was this idea about whether children should be able to make wills. So at the moment you have to be 18, and there are slight exceptions if you're in the armed forces, but largely you have to be 18 to make a will. And so this idea of lowering the age to 16 maybe. So again, that was something they looked at. So that was my whistle-stop tour of contested probate.